Hello viewers, Terry here again. We're back. Simply Legal is back and offering you the best videos, the best legal insights, and the best services that the legal world has to offer in terms of videos. So today we're here to talk about family law. With me here, I'm here with an esteemed colleague, someone who is very knowledgeable in the field of family law, someone who is going to discuss with me about the recent position in terms of succession, and we're going to dive into it and have a very interactive and lengthy conversation, but at the same time keeping you engaged and hooked. With me I have Mr. Martin here. How are you, Martin?
I'm okay. How are you doing, Terry?
The viewers want to hear a lot from you. They want to hear what you have to think about the case we will discuss. They want to hear how COVID-19 has been for you. How is the legal world treating you? How are things? Come tell us.
Thank you. Like I said, I'm Alex Martin Musime, a lawyer and with some passion in family law. Quarantine, lockdown, name it, has been quite a challenging time, but it has also offered me an opportunity to amass more knowledge in the field of law, to read more, research more, read the decisions. Yeah, that's how it has been generally. So there is a negative, but then there is a bigger positive to that.
Yeah, okay. So, what do you think? Where do you see the legal world going with all these cases coming in and changing case law and changing, what we thought was then before and right now?
One thing is clear from the lockdown, that the legal world is getting more busy. People are restructuring agreements. Families are rethinking many things, and also people are marrying much more. So courts have also been on hold for a long time. So there is too much going on now in courts.
Yeah.
So there is quite a lot in the legal world. No wonder the decision we are going to talk about came out just recently after the lockdown. So there's been quite a lot going on, and the legal world is really going to be so busy for this time.
Okay. So Martin, the viewers want us to talk about the case. They want to see what we have to say. This case, of course, is about Herbert Collier versus his very own mother, Eteria Collier. We have both looked at this case. We have both looked at its implications. What do you have to say about the facts? Maybe we can dive into the facts to help them better understand.
First of all, previously, Uganda being a very patriarchal society and so much, religion and then the culture being so patriarchal, there's been quite a lot of disparities in terms of rights in marriage, and in families. This disparity also continues. When someone has died, it also continues into succession. Now, recently, the courts in Uganda have adopted a position which is progressive in a sense, where a spouse who survives the other is the one who is supposed to handle the matrimonial property. Before, a person in their will could write and give their matrimonial property, mainly men could give matrimonial property, bequeath it to any person of their choice. But right now, courts have decided that, if it is matrimonial property, you do not bequeath it in your will or whichever form without the consent of the other spouse. So if you're writing a will, you definitely have to get the consent of another of your spouse. Now, this is in the case of the recent case of Collier. There's a case of Collier v. Collier where the courts have adopted that position. Yes. And you asked me to talk about the facts and the legal issues there.
We can share the facts. Maybe I can begin. Okay, viewers, we had a man called Israel Collier, who was the father of Herbert Collier. So Israel had built his wife with his wife, Eteria, and By then, they didn't have enough money to finish up their house. But Echiria, given that she was a midwife in Mengo, agreed with her husband that she's going to finish up the house in their block in Namirembe. Now, Israel, as he was growing older, noticed that he has 6 children, but Herbert was his firstborn. So Herbert eventually was given. He was basically the heir to his father. So Israel Collier gave to his son Herbert the matrimonial home which he had built with his wife, and yet he had formally given him a piece of land still in that Namirembe block. Martin, you can carry on.
Yeah, well, to add on what we're saying. So there is this gentleman who, in his will, writes giving the matrimonial property to the son, and the son, upon death, the property reverts to the son of the son. Okay, right now the grandson of the first initial person who wrote the will. Now, certainly the widow challenges that. The widow of the first gentleman, who was Israel, yes, Israel, challenges that and says you cannot. This will was written without my consent. Okay, so it's me who is supposed to take out. It's me who is supposed to own this property now because this was matrimonial property because I'm the surviving spouse, and court had to resolve that dispute because the grandson of this lady, Ekiria, is saying, you know what, this property was bequeathed to my father and now it reverted to me, and therefore I am the one who is supposed to administer it. I'm supposed to take it over. So that's where court had the bond. You know, it's where court had to make a decision. Okay, the spouse or the person who was put in the will. Needless to say, there was also challenges with the will. Okay,
It was defective in
yes, there was a defect in the will.
Because from where I read, I remember when I was reading this case, it showed that the late Israel Collier had bequeathed his matrimonial property in Namirembe, and also the rental houses owned by his wife privately in Mackingham. He had bequeathed them to their daughters, and yet these rental houses were owned by his wife, and she did not attest to. She basically didn't agree to that. So with her concealing the will, she had grounds to conceal the will. That's what I think, because she saw that this will was defective in nature. So for her, what she told the court was that my late husband died intestate, even if the will was there. I don't know what you have to think about that.
Yeah, I think that makes the point. You know, she and I think to an extent court agreed with her. Continuing to act on a defective will is in essence also sanctioning an illegality.
Yes.
So I think she was right in a sense. You know, although I have issues with the court in not applying the principle of severance. I don't know. I think we can go there later.
Yeah. I think we can dwell into that later.
Yeah, we can dwell into that later because I also have some issues with that particular decision.
Really?
Yeah, in saying that some property was not talked about in the will and then another was talked about, because in law there is a principle called severance.
Yeah.
Where you can deal with the property that belongs or the right part, okay, and then discard the wrong part. Now, because some of the property that had been put in the will did not necessarily belong to him, does not mean that the other property that belongs to him cannot be bequeathed to other people. You know, so I have issues with that. The issues of severance.
Let me just cut you short. At this point, I think we should replace you in the place of Judge Godfrey. Because at this point you're really dissecting the law, and I think this is what the viewers want to see. They want to see what other lawyers have to say about this recent position. Yes, you are saying, but however, wait, let me just cut you short. I agree with the severance part that we can remove out the bat from the court in terms of this property. However, the court could not continue with this defective will, because if they were to dig into the nitty-gritties of it, then I think they would have a lot of hardships given in the judgment. It's just my opinion.
You make a right one for sure. However, I would think once the will meets the minimum qualifications or standards, legal standards, has it been attested to? Okay, is the person making it of sound mind? Are they capable of knowing what they are doing?
It actually brings me to this question: what is a will in our legal terms? Maybe we can also discuss that for the legal man, for the layman to understand.
A will is basically that document, okay, that a person takes out, so that in the event of that person's death or when that person dies, the property that they talk about in that will or their wishes are put into effect.
Yes.
It is usually used in property distribution, okay? Yeah. So that is, in simple terms, what a will is.
And of course, we know that a will should be done with sound mind. The person, the testator should be of sound mind. The testator should be, of course, 18 and above.
Yeah.
The will can take effect when the testator dies, and the will should have witnesses.
That witnesses, it should be attested to.
So I think in this case, the late Israel Collier was actually of sound mind to make his will, and he passed all the factors. The only issue was he bequeathed what did not belong to him, and he bequeathed a matrimonial home that him and his wife had worked for, without her consent.
Yeah.
So I think maybe we can now go into the issues. Let's see what. I remember the first issue being whether indeed the late Israel Collier could be. So these issues that were raised in court, we can discuss them since we're already well acquainted with the case. Some of the issues were ranging from whether indeed the matrimonial property could have been bequeathed to the heir without interior's consent, and whether she was credible enough to get the letters of administration and also the jurisdiction of a court, that kind of thing. What do you have to say about the issues?
Yeah. Well, first of all, we talked about the first one in regard to a spouse not bequeathing or not giving out matrimonial property without the consent of the fellow spouse, okay, and that is very important.
Yes.
In telling us about the equal rights that are enshrined in our constitution, okay, the equal rights in marriage of the man and the woman.
Okay. Not to mention proprietary rights.
Yes, and
because the fact that she was a widow, and this Herbert wanted to evict this old woman, and yet proprietary rights are what can take more precedent over this whole issue of heir and what.
Yeah, so that's a very important issue, and court resolved it very well, giving the rights to a surviving spouse, okay, to remain with the property, yeah. And then secondly, on who is the right person to take out letters of administration. You know, should a person die intestate? Intestate means a person has died without leaving a will, okay. So court again re-emphasized it, and it has been emphasized before that it should be the surviving spouse, okay, that should get the letters of administration, because the surviving spouse, and in this regard the lady or the widow, is in the best position to administer the property of the of the deceased husband or the deceased spouse. In a sense, that's very progressive, okay. It gives them, because this person understood their spouse and is able to carry on their wishes, okay. So yeah, that's also another issue that came out. Then thirdly, the issue of what are the duties of an administrator, okay? When you take out letters of administration, when you apply for them, it's also another process. You have to get a lawyer and then apply for letters of administration. Okay, even without a lawyer, you can, but it's better you use a lawyer to apply for letters of administration. Now, there are duties for an administrator. Among them, you must, of course, clear the burial expenses, the funeral rites, and all that. But then, you must file what we call inventory.
Yes.
It's in essence an account.
An account of the way of distributing the property. Actually, I remember. Okay, now we can just rush to the judgment. Remember in the judgment of this judge, Judge Namobi Godfrey, he said that he orders that if the widow is to stay in her matrimonial home, then in a space of 1 year, she must provide the inventory and accounts of how she distributed the property. And I think that was right. It's just unfair. I think in the eyes of the law, he cleared out everything. He ironed out every issue, and I think it was good. Personally, I think the house should really have remained with the wife, the widow. It should not have gone to her, but because he was already given property.
Except the issue of severance, the principle,
Yeah.
which in fact was even a contention in the Supreme Court in another case. I believe it was a great decision, recognizing the rights of a woman, very importantly, given that our society is so patriarchal. So it's a breakage from the norm, of putting women down, and also re-emphasizing the responsibility of an administrator, okay, and also again re-emphasizing or holding sacred the will of a person who has died, and their wishes. So, in my view, I hail court for that decision. I hope it is not appealed, which I don't think it will be appealed. I don't think so. Yeah, it was a great decision and a very big development in one, constitutional law, and also family law in Uganda.
Okay, and I hope we get to see more changes in the law, because we should be seeing development in the country, and of course the legal sector is a very big development in the country. So thank you so much, Martin. We have been so glad to hear from your well of legal knowledge, and we thank you so much for giving us your insights, and we hope to host you soon on the channel. Thank you so much, and
Okay, have a great time. Thank you.
okay, you post. So guys, thank you so much. Thank you, my viewers. For those who are new to my channel, you can always see the subscribe buttons just below the video, and we Simply Legal continue giving you the best insights we can offer you, and I'll see you next time. Peace.